Here, here's a great question right here. See, I'm not always an a-hole with every comment and stuff. If somebody has a great question, I'll acknowledge it's a great question and try and answer it as best as I can. I just got a few people came on my page and lied and said judges always do this or they never do that or every single courthouse you always have to do this. If you're looking for gold in, let's say you go to Mongolia and let's say you go to China, familiar cities. If you're or Australia, if you're looking for gold in Australia and you look in Sydney and Queensland and a couple other cities, and you say, "Well, there's no gold in Australia." If you haven't scoured the entire country, you can't say that there's no gold in Australia just because you looked a couple places and you came up with nothing or you had a problem in a couple of places. That doesn't mean that's every single place. You would have to, in order to make a definitive statement. You know what a definitive statement is? If you don't, then you should shut the hell up and never comment on my page. If you make a definitive statement about the entire court system or all judges, then you better have researched all judges. People come on my page and say, there's no way a dad gets custody without an attorney. I show you my winning court orders. Shut the F up, bitch. So, anyway, let's get to the good question here. How is it possible that child support is making 10,000? Looks like my eyes are blurry right now. 10,000. Oh, they're saying I make 10,000 more a year than I do. I've given them all my paperwork and several times to prove my income. What can I do? Thank you. This is a great question and is really good also because I've never had this question. It's kind of unique and I've never really addressed this issue. I've only done it like with people in one-on-one consults, but um, let's give you an example, like in Washington law, how that's called imputing your income. If they say you should be making, or you could be making, or this is your income, but they have to make a definitive finding or a specific finding on paper. Are they saying that's your actual income? Because if you prove otherwise, if you prove that it's not, then I'd be doing a motion for reconsideration or an appeal. But if they're saying that they're imputing your income on what you could or should make, you need to make that distinction. So I'm not sure how they screwed you on your income amount. But let's take a look at the law in Washington and how I argue it. Okay, so I'm going to Google RCW 2619. Let me just Google 26. I forget the exact section. I think it's it's 071. Okay. Standards for determining income. So I know you're probably not a Washington case, but this is the logic how I approach this stuff. So RCW 2619-071, how they consider income, income, salaries, wages, overtime, severance pay, capital gains, all this stuff is income, net income, imputation income. So we have a law that says, like most states have, they can impute your income, and here's how they do it. They can impute your income, full-time earnings at the current rate of pay. So if you have a history of working as, I don't know, a civil engineer, an engineer who designs roads for the city or something. You're making 100 grand a year, and now you're flipping burgers at McDonald's. They could say, well, there's plenty of these jobs available. You didn't look for them, so that's the full-time current rate of pay, or historical rate of pay based on reliable information such as Social Security or employment security data. Full-time earnings at past rate of pay where information is incomplete or sporadic. So they basically go off of, if you come to court with tax returns, and up here they say when you have to consider all income and resources, you have to verify it with tax returns, and some counties up here require 6 months of pay stubs, 6 months of bank statements. But back to how they impute income. Earnings at 32 hours minimum wage, full-time earnings at minimum wage, median net monthly income. So these are all the things that the court has discretion and options to use. So, but when they do that, in order to impute your income, there's a chart that says what you should be making by a certain age, which is rounded up or derived from Bureau of Statistics, United States Bureau of Statistics. Anyway, so I'm kind of giving the background, but there's okay, so here's what I'm really looking for after showing you that. The court shall impute income when the parent is voluntarily employed or unemployed or underemployed. Okay. So what that law is saying back there is that they can impute income only when you're voluntarily unemployed or underemployed. Now, I'm still not sure if that's why they slapped you with that, or they just lied and made stuff up. This is where you got to pay careful attention to what they're saying in court. If I'm dealing with a Washington case, or if I'm going into court and they try and impute my income, how do they know that I'm voluntarily unemployed or underemployed? Now, I might have a degree in computer science and I'm flipping burgers at McDonald's. They might say, there's 40 jobs in your area within 10 miles or 20 miles. And I need to see an attempt to be looking for those jobs. But we're going to assume you're voluntarily underemployed. But still, how do they know? This is where you need to know the rules of evidence. Because rules of evidence say you can't talk about my state of mind. Who's the only person in the world? Now think about this. If you are intentionally trying not to work and get paid under the table with a side job, but a regular job on paper, working for the system or the man or whatever, if you're trying to underwork or work less hours or work a job that when you're qualified for something better, if you're intentionally doing that, who's the only person who knows your intentions? What I'm really asking is, who's the only person who knows what's going on in your head where you're voluntarily, intentionally trying not to work this job? You. So who's the only person who could testify to your state of mind? You. And there's an evidence rule that says that. I talk about that in a couple thorough videos on YouTube and I think TikTok. It's ER 602. Nobody can testify to anything unless they have personal knowledge. Who has personal knowledge of your state of mind? Only you. You can't read my mind right now. I'm thinking of my favorite football player of all time. You can't know who that is. If I'm thinking, man, I'm going to try and not work a job. I could work this job, but I'm going to intentionally not apply for it and not work it so that I can avoid child support. How does anybody know you're thinking about that? See, when you read the law carefully and you read every word and think about what does that really mean? Oh my God, there's no way anybody could test. That whole law is moot in Washington if somebody has the balls to argue it because nobody could testify and say, oh, he's voluntarily underemployed or unemployed. Where do you get that from? A judge can't read your mind. A judge can't testify to your state of mind. A judge can't testify at all. That's in the evidence rules also. Did you know that? Did you know that a judge can't testify? They can't interject their own thing when they talk about, oh, I usually have cases like this, and usually what happens is the dad is like this or the mom is like that. That's them testifying. That's not your case. That's not the facts in your case. They're introducing something outside of the case and they're testifying. Have you ever objected? Say, objection, Your Honor, you're testifying. I know you're not supposed to. You could be nice about it. Say, in my case, I'll tell my judge, objection, you're testifying. I told my judge that he needed to kick my baby's mom's sisters out of the courtroom. My baby's mom has two beast, ugly sisters who never had a boyfriend that hate me. They were sitting in the courtroom behind us, and ours is a sealed file case. Nobody can be in the courtroom. I told my judge to kick them out. He said, your time is running, James, Mr. Christensen. I said, are you going to kick them out? This is a sealed file case. You're supposed to kick them out. And he said, your time is running. And I said, so you're going to be the only judge in the history of this courthouse who didn't kick people out because it's a sealed file case, and you're going to let them in the courtroom? Well, you better stop them from heckling me because last time you let them in the courtroom, they heckled me. Your time is running. Oh, I said, oh, you don't want to say anything on the record because you're afraid I'm going to find something wrong with what you said and get you reversed. So you're scared to say anything, aren't you? That's what I told my judge. I also told him that him and my baby's mom's attorney, they both hate me because I date beautiful women and they have hideously ugly wives. I told them that on paper in a contempt hearing they were doing against me. And that was like toward the very end. And I knew the fix was in because I got my judge reversed in the Court of Appeals and he was taking it personally. Anyway, so you could tell the judge, hey, you're testifying. Now, if they're slapping this on and you added it up and you said this is my income and they said that no, this is his income, the judge, if you testify that you make 60 grand a year and they testify 70 grand a year, and the judge isn't telling you how they got it, you have to assume that they just believe them. If they don't have the evidence, you could say it's not based on any facts or substantive evidence. Make certain objections to set it up for trial or appeal. I'm sorry. And then I would say you need to make a finding of fact where you got that from. The courts always need to make finding facts. Go watch my video on YouTube talking about finding facts. Go on my YouTube channel and type in the word finding fact.